Oh, there we go.
There we go. Good afternoon, everyone. My name is Tiffany Van Buren. I am the Deputy Director of the Berkeley Property Owners Association. And I thank you all for being with us today for another installation of our wonderful asset protection experts, BarthCalderon. We have Paul Hitchcock and Harry Barth Esquire with us today. We may or may not be joined by Jerry Connery. He had some scheduling conflicts that came up unexpectedly. But without further ado, I will keep an eye on the waiting room and turn things over to you, Paul and Harry, and I'll be right here if you need me.
Yeah, thank you, Tiffany, for having us. Hello, everybody. For those of you who don't know me or us, I'm Paul Hitchcock, and this is Harry Barth, our founder and senior managing partner of Barth Calderon. We're headquartered here in this building near Disneyland. We're just talking about that because I guess it's about 95 down there right now. I actually live in Marin County. I'm not far from all of you over here in Northern California. I'm here now. And we have a very tight alliance with the Berkeley Property Owners Association. We've been around our business for over 34 years. Harry, as I said, is the founder and our top speaker for the firm. So we have about 12,000 clients across the country. We put on about 40 workshops a year to many organizations across the country, many apartment associations. We are their number one speaker. And we have 30 people at the firms, attorneys, support staff, and very much in tune to rental property owners. We have alliances with landlord attorneys, and we have real estate attorneys at the firm, so we understand, your business. And Harry is an expert in asset protection. And I just got to say, as we get into this, and Harry's going to highlight this, is we get a lot of calls from landlords that are going through things related to asset protection, which is why we're focused on this topic. And Harry will describe what it is, why you need it, and get into some nuance of asset protection. And we will open it up for some Q&A. Always want to say that in the chat there, Tiffany, I'm assuming everybody can see the chat. Is that correct? Yeah, so there is a link in the chat because what inevitably happens is people have questions on their own personal planning. We'll take some Q&A today, but if you want to get one-on-one with Harry and the team, you can click on that link, 100% complimentary, and you can get on a Zoom video phone call with an attorney on the team to look at your own planning. And happy to answer questions and get some clarity for you on how to get protected. And I'll say that Harry is the best guy to be talking about this. He's got a doctorate degree, two master's degrees, about 12 other advanced planning degrees, and as I said, top speaker to apartment associations everywhere. So, Harry, let's get into
Wow, Paul, I'll give you $20 for that one. Thank you so much.
it.
Well, it's great to be here with everybody. Some faces I even recognized from the last time I spoke to the group. Um, we're going to talk again a lot about asset protection. Why? I can't understand for the love of me um, why sometimes we get some hesitation about trying to protect that which we have worked so hard for in the kind of nutty world that we live in. And I'm going to talk a little bit about why the nutty world is the nutty world that we live in and why the situations are the way that they are. And then we're going to talk about some specifics which are very much relevant to the ownership of real property. And we're going to talk a little bit about insurance as well and the interplay and the marriage of insurance with legal asset protection procedures. So we can start with the general admonition, everybody. Who doesn't want to protect their assets? I've been doing this for 45 years, and I'm yet to hear anybody turn and say, no, 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 I don't want to protect my assets at all. I want them to be exposed to predators and creditors and every other individual that wants to try to hurt my family and our network. That just doesn't happen. Everybody starts with the premise that they want to protect their assets. It's why we buy insurance, why we form LLCs, why we form corporations, why we put clauses inside our leases. Everybody wants to do that. However, I guess the devil is in the details, and today I want to get into some of the details with you as to maybe some of the urban myths that are out there about reasons why people don't structure their assets properly for protection, and some of the things that we have seen over the years that I'll share with you today that may be a little eye-opening. Um, so what I'd like to do to start today is a little bit of a definition of asset protection, ladies and gentlemen, is not about being in a courtroom. I want that to be clearly understood. Asset protection is about arranging our assets in such a way that in the event, God forbid, we are exposed to liability, that we have the opportunity to settle this, hopefully within the insurance policy limits that we have, and quickly. No business owner or real estate owner does really, really well in a courtroom. I can assure you that. But so that's what it's the arrangement of assets in a way to make things much more favorable for you. You know, let's talk about three paradigms and then some statistics, and then we'll get into specifics. So, the first paradigm and the most important paradigm in all of asset protection, this is number one, is that we don't attempt to engage in asset protection planning after the event has occurred. Now, this may seem ludicrous to all of you, but we kind of know that, hey, look, if God forbid we crash the car and we injure some people, and that's not the time to be calling the insurance agent and say, hey, we may not have enough liability insurance. We know better than that. But we have 12,000 clients over 45 years, and we get calls, believe me, no matter how hard we try, this happened at my property, this accident occurred, this liability happened at my business. You're an asset protection attorney in an asset protection firm. What can you do to help me? And then I usually get the admonition that goes along with it. Well, I haven't gotten a letter from a lawyer yet, and I haven't been sued yet. We hear this consistently all the time because many of us believe, oh, and Jerry is here too. So, hi, Jerry. Jerry made it. Many of us believe that the scenario is that it's when we hear from the lawyer that that's when the legal action begins. The legal action actually began at the time of the event, at the time of the car crash, at the time of the liability at the property. At the time of the event is when it occurred. So that's the most important thing. So we need to get planning in place preemptively and proactively long before any liabilities arise, for order it to be professional and to be protective. The second component in the paradigm, before we get to the third component, which will bring Jerry into the picture, is that there's an urban myth. And I don't know where this urban myth comes from, but it's out there, and it's not net worth related. It's not related to how much property we have or anything else. I don't know where it comes from, but it's people think, or a lot of people think, that the living revocable trusts that we have put together for our family estate planning, the glide path to the future, the dynasty, the moving of wealth from one generation to the next generation, avoiding probate, trying to mitigate estate taxes. All of the reasons why we put together our family trusts are critically important, but those trusts do not, I repeat, do not provide any asset protection whatsoever. People seem to think that a trust is an asset protection tool. Certain types of trusts are asset protection tools, and many trusts, the common trust that we use for passing our legacy to the next generation, is not. Then people will say, well, my home is protected, right? Because I have it in my trust, or my bank account is protected because I have it in my trust. And the answer is more likely than not, no. There is no protection under those circumstances. So it brings us to the third And the third is my segue into Jerry. And that is people say, I have insurance for this. I bought insurance on top of insurance and umbrellas on top of umbrellas. And what they're basically saying is that, look, I've insured this. Um, and the over reliance on insurance is just as bad as the over reliance on legal procedure. It's the common marriage between appropriate and proper protection that Jerry's going to talk about and legal procedure that gives us the type of protection that we really, really need if we're going to own property, especially in California. Jerry will address some of the following issues. One issue, people buy $2 million worth of liability coverage. And what they're saying is that they feel that the amount of liability that they have won't exceed the amount of coverage that they have. Well, what if we have a $3.5 million liability and I have $2 million worth of coverage? Well, how much is the right amount of coverage? That's a very difficult question. Jerry's going to address that. The other one is that in most places or many places within the insurance industry, we kind of get the picture that these umbrella coverages that we buy, whether it be a landlord tenant or personal, that it's an umbrella, covers everything. Well, it doesn't. They're loaded with covenants, conditions, and exclusions. Maybe Jerry could talk a little bit about mold exclusions and other types of exclusions that exist within policies. So there are good contracts. We will talk about who needs to be insured, how things need to be insured, and Jerry, we'll jump in a little later as I get into the details of LLCs. But let's just talk about the concept of insurance and its interrelationship a little bit with legal procedure. And then after Jerry finishes that, guys and girls, we'll jump in and talk about the statistics and the need for all the protective structures that we're talking about today. So Jerry, take it away a little bit. Good to see you.
Good afternoon, everyone. The the first question that Harry talked about was what's the right amount of cover? And the answer is it's the amount needed at the time of a loss. That would be adequate to protect you and your assets from whatever that claimant is representing. And so how do you choose what's the right number? Well, one way to choose it is to consider what your net worth is and making sure that you have adequate cover to cover that net worth. But Harry and I are here to tell you that there are other ways to do things. And one of those things is to silo risk, where you take certain assets and you put them in separate legal entities so that the aggregated value of that entity doesn't exceed the value of that particular asset. And any loss arising from that asset doesn't impact any other asset because it operates within its own silo. Under those circumstances, if all the assets are broken up into separate silos, then the amount of umbrella coverage that's needed is the amount that's going to cover the personal net worth of the person that's managing that asset, not including assets that are separately insured and separately siloed elsewhere. That sounds very complicated. Well, let me tell you, there's ways to figure out the right answer. And you need to talk to a risk manager or a very educated insurance broker. And the question that you need to ask is that actuarially, what is the percentage of losses that occur to people like me? What are the sizes of the average? What is the size of coverage that person typically carries? And what is the size of the judgments that have been made in that category? And when we go in and we put that data in, it will come back with three numbers. The first number it will tell us is the number of people that fit that category. So what percentage of the marketplace is you? The second is it's going to tell us what the average protection is that group of people purchase. And third, it's going to tell us what the size of the lawsuits have been that folks in that classification have been impacted by. And they get all of this data from public record, from court records and from Department of Labor and Department of Commerce. But three very responsible resources for data, and then they crunch that data to understand, where you're at, and we can help you figure out where the sweet spot is. The other question that Harry talked about was, what is the interrelation between corporate structures and legal maneuvering through, in other words, utilizing the tax and tort code to your fullest advantage. That is the hand, and insurance is the glove. And the whole idea is for them to fit like hand in glove. And when there is a misfit, there's going to be a frustration on somebody's part. Either it's going to be that coverage doesn't meet the need, or there's going to be that we wish that the language of the contract would have read a little differently, and now we've got a problem because of the language of the insurance policy. So the thing is that you need all of these policies and all of these legal proceedings that we're talking about, and I'm talking about LLCs, S corps, C corps, partnerships, associations, as they are. These assets are put into these kinds of circumstances through legal proceeding, okay? Then the key is to make sure that the insurance meets the needs that organization has as a result of that asset being in it and the operations that it does. It sounds complicated, but it really isn't. It's really a matter of bubble sorting. It's an array. And we're going to go north, south, and then east and west, and we're going to find the box that you fit in. That's kind of how it works. Harry, I think at this point,
let me take it from here.
Harry,
and
can I
talk about a
say
few things.
just a quick thing, Harry, is that
Sure.
I want to tell everybody, because Jerry wasn't here. Jerry Connery is a principal of his own firm, Connery Risk Management Services, and that link I put in the chat is also an initial complimentary call with Jerry, who will look at your insurance. And we get a lot of calls because my team takes them, the hair on fire calls. A lot of them have to do with the insurance was not properly put in place. And so there's trouble. So Jerry, if you want to get with Jerry as well, same link. I just wanted to make sure everyone knew that.
Thank you. So yeah, and we'll circle back to that when we talk about the entities. I'm going to talk to everybody today about specifics, not just generalities. But before I get to specifics, we got to take a look at some statistics. And why statistics? Because as Jerry was talking about earlier, and I'm talking about, we have to understand the playing field that we're operating in. We have to understand that, because if we don't understand that, there's no call to action that has to take place. So let's take a look at some interesting statistics. I think they're kind of mind-blowing. So in 2024, all right, how many lawsuits do you think were filed in the United States of America? It's kind of mind-blowing, but I'll tell you, 50 million lawsuits were filed in the United States of America. Unbelievable. Now remember, every interaction with the legal system, whether it be immigration action, tort action, divorce action, criminal action, tax action, contract action, immigration action. Anytime we're asking the judicial system to do something, it begins with a complaint. All right. There are 50 million complaints per year filed in the United States of America. It's just that to almost avoid a brush with the legal system over the course of our careers is going to be almost impossible. But here's some further statistics which are critical to today's conversation. 95% of all litigation in the world occurs in the United States of America. Only 5% occurs outside the United States of America. Now, that's another mind-blowing statistic. Why is that? Well, some of it is kind of makes sense. We are still the world's largest economy. We have the most businesses, the most LLCs, the most corporations, the most limited partnerships. We have a lot of individual entrepreneurship, and we are a nation that's governed under laws. And so we're going to have more than almost anybody else. But there are a couple of other things, and these affect us very much today. The other thing that affects us is that we have the American system of legal fees. The American system of legal fees is absent the contractual change, each party pays their own fees. The winner does not pay, I mean, the loser does not pay the winner's legal fees. This is very interesting. In most places around the world, if I bring a baloney action against you as a landlord, as a tenant, all right, and it's just a baloney action, but I'm a baloney lawyer, and there are no contingency fee defense lawyers, it's already costing you money. And at the end of the day, they're going to wind up giving money, say, well, it's going to cost $200,000 to defend this. Let's just give them $150,000 and have them walk away. So what happens is that we get a tremendous amount of, I would say, non-meritorious lawsuits happening in the United States that don't happen in other countries because the other countries use the British rule, and the British rule is inherently, hey, if I sue you and I can't make my case, I'm going to pay your lawyer's fees. That puts a chilling effect on bogus lawsuits. We don't have that. The next thing we have in the United States, which pretty much doesn't, I practice in many states, and I practice in a couple of other countries, is something contingency fees. All right, this contingency fee business, and that is, let's put it this way: it was noble when it started. The American judicial system, ladies and gentlemen, is very expensive. And therefore, for people of lower income and moderate income means, it was very difficult for them to get high quality legal representation. So we developed in the United States of America this unholy alliance, which was started as a noble purpose, where someone of lower or moderate income needs would be able to partner with a law firm by sharing the fees upon the result and enable someone to seek redress for something that terribly happened to them. Sounded good. But all of us, especially those of us living in California, a number of years ago, late at night, what we see? We said people selling used cars. Cal Worthington selling used cars. All the used car salesmen came on at night, all night long, used car salesman, used car salesman. What do you see now? Morgan and Morgan, Sweet James, Larry H. Parker, Easton and Easton, the Law Brothers, Russ Brown, motorcycle. All we see is billboard lawyers all day long. If you eat the wrong hamburgers and it makes you heavy and you have heart disease, maybe we should sue the hamburger company. Cigarettes, bad water, it goes on and on. Multi-billion dollars of lawsuits are done as a result of these contingency fee operations, and it encourages lawsuits. And third, the issue that we have is punitive damages. In most countries, there's no such thing as punitive damages or exemplary damages or special damages. And Jerry, I want you to talk to that when we talk about insurance contracts in a minute, because what we have here, we've developed a system that basically says, well, Jack, maybe you are a little more than negligent. Maybe you're grossly negligent, and you were wanton, willful, and careless in what you did. So not only are you going to have to pay all the damages that you caused, all right, even as a landlord, but perhaps you need to pay more. We should punish you by taking your assets away from you, other assets, to punish you and send a message. This is interesting. And because, hey, let me ask you a question. How bad would it be how can we punish Jack, if Edna, Jerry, is paying the bill? So why don't you talk to a little bit about the limitations of insurance? And also, if you would, Jerry, talk a little bit about something else that a lot of people don't recognize who are in the real estate business, about judicial action, administrative action, regulatory action, and how that differs from property and damage insurance. Jerry, take it away.
Well, liability first of all, insurance as a word it's an entire industry. It's a $1 trillion industry. So when we say insurance, I want to be very clear that every contract and policy has conditions, covenants, it has warranties, and it has exclusions. And the language of that contract is very specific about what it will react to and what it doesn't react to. When it comes to typical liability claims, it's under the environment of a general liability policy or comprehensive personal liability, which is what you would find on a homeowner's policy or as part of auto liability with a personal auto. And the coverage requires that there be two things that happen, or three actually. That allegedly you're the negligent party and the cause of the injury or the loss. Secondly, that the loss is specific to a bodily injury. Or third, that it's subject to damage to my property caused by your actions or inactions. Okay, those are the things that general liability and comprehensive personal liability responds to. But what happens when somebody is sued economically? You failed to deliver the services rendered timely, adequately, and it cost me financially. I'm suing you. That is not something that general liability or comprehensive personal liability is going to respond to. So landlords that are out there and that own buildings and have tenants and they get sued over a contractual issue. They think that their insurance is going to be adequate. And unless they have some form of management liability, and it comes in several flavors, the category is management, which means that the organization can be sued for the way it managed its operations. That's the definition of it. And so therefore, it doesn't have the strict requirement of bodily injury or property damage. And sometimes it even excludes against those things to make clear that it's in the professional space and or the management space and not in the general liability space. But that kind of cover would be professional liability or malpractice if it is a service provider and the claim is coming from a customer. It's employment practices if you're being sued by an employee or somebody that you could have employed or somebody who argues that you should have employed, or the way the culture and the environment and their work environment operated you as the employer are responsible. So any of those kinds of claims are called employment practices liability. And then there's entity to entity. And this is directors and officers cover. And why? Because directors and officers was originally designed to protect public stockholders against the actions or inactions of directors of public companies. So if a private stockholder was impacted negatively financially by decisions or indecisions on the part of management, they could be indemnified by those actions. It also could be flipped around and looked at as if I am a director, I'm putting my personal assets in exposure because I'm a director and I'm acting as an individual. So those are my personal assets that would be exposed, and a directors and officers policy indemnifies me so that my personal assets are not the ones indemnifying me for my role as a director. But the point is that if the lawsuit that arises is contractual, if it is financial in nature, and it's between one business and another, one entity and another, a vendor and a customer, okay, any of those kinds of circumstances where the allegation is contractual or failure to provide or financial loss caused by delay, then all of these kinds of things need to be insured the right way. So if somebody is turning to their homeowner's policy or they're turning to their general liability policy on their habitational risk, and they're wondering whether or not they're going to be protected, it depends on the circumstance. If your neighbor is suing you because of damage to his property and the damage is emanating from yours, covered. If he's suing you because your tenants are making noise and keeping them up at night and making their life miserable and therefore diminishing the value of their property or diminishing their life circumstance and sues you over it, not covered. Only professional liability is going to protect under that circumstance.
Hey, Jerry, what if they're being sued as landlord for discrimination?
There's a good one. Okay. Is there bodily injury? No.
No.
Is there property damage? No. So the only way that discrimination is protected, and by the way, thank you for mentioning that one. It's a better example. I love you, Harry. This is why we are the Dog and Pony Show. Discrimination is specifically protected under the professional liability arrangement. And why? Because it is a customer and or somebody who would have been a customer or could have been a customer other than what they're alleging you did that prevented them from having that experience. And they're claiming that you did it because of the color of their skin or the size of their body or their sexual orientation or whatever they dream up as the reason why you just discriminated against them. You have to have professional liability in place. It's malpractice insurance or it's real estate E&O. Those are all the things that, and if you are utilizing a manager, if you're paying a manager out of your rents to manage your property, you need to make sure that that manager carries general liability and professional liability and that they indemnify you for any of their actions or inactions. Anything in that contract between you and them that says it's their responsibility to handle, that you've given them the budget and the authority, and now you're being sued because of a habitability issue, claiming that there's vermin or there's cockroaches or some other circumstance. Again, your manager is indemnified by you when it is bodily injury or property damage. That's why you buy a habitation policy. But you should be indemnified by them through a professional policy. And if you're going to do your own property management, you need to buy your own. Or you're going to pick up that phone and you're going to call Harry after talking to our good buddy on here and saying, hey, I got sued for this. How do I solve this problem? Too late.
Yeah.
Too
So
late.
Jerry, I appreciate that. And so basically what we're saying is that we've seen cases, the regulatory stuff from cities, regulatory stuff from the state. It's just not covered. People, they have a landlord tenant. It's just not covered. Mold issues are excluded. But bottom line, insurance is critically important, but it's not the know all end all. And that segues into us to the gravamen of today's conversation. Let me talk to all of you about LLCs. And let's talk about the good, the bad, the ugly, and let's talk about some of the falsehoods that exist out there. Practically, almost universally, most real estate, ladies and gentlemen, should be held in limited liability companies. And let's talk about the reason why. What do I see? I literally, about an hour and a half ago, was working with a client. And they had 14 pieces of rental property, and each piece of rental property was housed within their living revocable trust. That's the way it had it structured. That way it's had it structured for several years. And so we were talking, and I said, well, who's the landlord? He says, well, my trust is the landlord. Well, the trust is you. And please understand that from any one of these 11 properties, and any one of them, that the liability that you have as the landlord ends with your bankruptcy. What? Yeah, it ends with your bankruptcy. It's your entire net worth is on the line. So at property number one, we had a liability, sue the landlord. In this case, it was a husband and wife. All right, because it was the same as the trust, and it ends with your bankruptcy. I have no idea why anybody would engage in the sole proprietorship business of rental real property without a protective entity around it. So let's talk about that a little bit. So people always say, well, can I put more than one property in an LLC? Sure. You could put 100 properties in an LLC. You could put 200 properties in an LLC, or you could put one property in an LLC. And let's examine that for a second, and we'll talk about insurance. So if I have 5 properties, and each one of those 5 properties has, let's say, $500,000 of net equity in them, and each one of those 5 properties are placed into a LLC. Harry's Real Estate LLC number 1 has 5 properties, $2.5 million worth of equity. Now, my house is off limits. My bank accounts are off limits. My brokerage accounts are off limits. My retirement plans are off limits. All of my other assets are off limits. But inside that box, where the landlord, assuming run properly, if there is a liability from any one of those five properties, all five go down. It ends at 2.5 million. But I just created that. Now, what did I say? Now, if I would have changed that a little bit, just a little bit, and said instead of one LLC holding my five properties, I had five LLCs. One, two, three, four, five. Yeah, California, 800, 800, 800, 800, 800. We'll talk a little bit whether California makes sense or not. Now, if I have a liability at property number one, which has 500,000 of equity, it will end at that 500,000 and the other 2 million is not involved. I don't quite understand the aggregation. We're trying to save some LLCs, which are relatively not too expensive, not too burdensome, and we're exposing significant amounts of equity. I don't get it. It doesn't seem to make much sense to me.
Harry, do
And
you want
there's
to take
even
questions? Do you want to take questions that are coming up or no? Yeah.
You will take a question in a second.
Okay.
But I want to just describe the other side of the liability, then we'll start taking some questions and we'll talk about insuring it. The other side of this, so the liability, so to me, the more that we can segregate, or you determine from a business perspective, I don't want more than $600,000 worth of risk or $500,000 worth of risk in any one box. You control that as business people. You control that as landlords. You control the risk factors that are there. It's not the time to save money on LLC creation. It's much better to compartmentalize, as Jerry says, and have silos for those separate properties. But there's another side of this that's critically important, the one that's missed more frequently than not. Sometimes, and many times, the liability, ladies and gentlemen, does not come from being a landlord. The liability came because you had an accident on a freeway. Or I'm picking that as an example. Now the billboard attorney is after you. You had insurance for $1 million, but this is going to be a $2.5 million claim. All right. So where's the other $1.5 million come from? So now we're looking at what you own. And in your individual names or in your trust, there are those five properties. So the plaintiff's attorney can reach, it's on record, can reach each and every one of them, put a lien on it, foreclose on it, and you've now lost your properties. So the liability, we have the liability coming up from the property itself, and then we have liability coming from the owner of the property down to the property. Believe it or not, more properties lost that way than the other way. So now I look at it and all your properties are gone. If those properties were properly encapsulated in a proper jurisdiction, in a proper LLC, the remedy that would have been available to that plaintiff's attorney from that car crash would have been nothing more than a lien over the distributions of income that come out of the LLC. I repeat that. A lien over the income that comes out of the LLC. And they do not get managerial control. So you have a property or five properties encapsulated properly in an LLC. I can no longer take them away from you. I can't, you now collect rent, you keep it in the LLC, put it in the LLC bank account. It's still there. All right. You can do 1031 exchanges. You can add more properties in that LLC, and I still can't get in. And since I have no managerial control, I can't even force you to make a distribution. So while we're negotiating, while we're trying to turn around and solve this problem, you still have all the properties in your portfolio rather than have them lost. And most importantly, we're in a negotiating position to try to drive them to the insurance that we've gotten from someone like Jerry, and keep them away because it's not so attractive to come after you personally. Talking about that, though, Jerry, and then we'll take some questions. What's the problem with insuring? Some people have the wrong insurance, don't they, when we have these things structured properly? Can you talk to that?
Structure is extraordinarily important, and I am going to challenge all of you right now that are on this call to take 5 minutes 5 whole minutes to make sure that this is not the case for you. If your property is in the name of if your policy, is in the name of an individual or a family, if that's the first named insured, if that's what the bill says, the first name on the bill is your personal name, the only time that should be the circumstance, the only time, is when it is held as a sole proprietorship or it is held in a trust. The only time. And if it is a trust, it needs to say your name and then comma and the word trustee or some acronym for trustee. If it doesn't do that, then you have not informed your insurer correctly of who the owner of the property is. So when you go and do extraordinary effort through your attorney, you're trying to avoid taxes, so you have things in a trust, or you're in an LLC, or a corporation, or a partnership, and that's where your and that is where your asset is owned, then you need to make sure that the first name on the insurance policy that's protecting that is that name. If it is not, it is highly unlikely that you are properly insured, and it is highly likely that if you were to be sued in the name of that entity, that your insurer would deny the claim because it is not a party to the policy. Now, here's the part you're going to kick your fanny over. There's no cost difference. It's a matter of it being vested properly and that the insurer understand who the risk is. And when there is a lack of understanding, and it's because there's assumptions made, this is when everybody goes sideways with their insurance. And weeks and months can be added to a claim's life because so much time is spent sorting out the very thing you bought a policy to actually help you with. And why? Because the person who bought the policy is not the one who had the claim, at least in the eyes of the underwriter. Now, another area, and I know we're talking a lot about liability right now, Harry, but I think that we also need to acknowledge that in the world of landlords and property owners, that property itself is an extraordinarily important component of cover. And all of us on this call have gone through a period of time over the last 5 years in which we've seen nothing but tumult in the insurance world. And if you were the owner of a 5 unit or more apartment complex and you had State Farm as a client, in the last 3 years, you've lost that cover. And you were paying premium in let's call it here. And now you're paying, my hand is off the chart, okay, with an insurer you've never heard of, because you got non-renewed. And the reason for that is because State Farm withdrew from the state of California. And when it did, almost 31% of the entire marketplace went without the carrier that it had been relying upon. So 1 in 3 policies basically was being set up for non-renewal. Well, the marketplace, when you have that kind of a gargantuan cornerstone organization that's doing the insuring, suddenly withdraws from the market, well, you don't have that much capacity everywhere else to pick it up. And so many people found themselves in a situation in which their circumstance had been underwritten to the point that their building was too old, or their property was too close to something they couldn't control, or they had the wrong electrical panel in their property because somewhere in some back east state, some loss arose out of one of those panels, and so they decided they don't want to insure anything with those panels anymore. How many of you on this call have experienced this stuff? How many of you have been incapable of budgeting your insurance costs over the last few years? Well, just know that we are not impervious to this, and we are aware and we care. And so the key is not to become victims like those in the Palisades who found themselves being non-renewed, thrown into an environment where they couldn't get the proper cover, and then the worst loss in record takes place. Just be lucky that you weren't one of those folks. But today, take that 5 minutes to make sure that your policy's in the right name. And if you're not sure, call us. We'll just 5 minutes, we could tell you yes or no. You've got that the cover's written the right way.
Super, Jerry. Thank you. Thank you very much. Now, Paul, we saw some questions coming across. One of them I saw coming across, I want to deal with. People. There was a question asked about if we're taking the property out of the living revocable trust and putting it into an LLC, will that cause reassessment under California law? And the answer is, when done properly, the answer is no. When done properly, it's not going to increase your taxes. There's not going to be any reassessment whatsoever. As long as it's all done properly, there's no issue with that. Another issue that comes up that we hear a lot is that, well, what about my bank that has a loan on that? Are they going to default the loan, accelerate the loan, and get it done? I could tell you there's probably over about 6,000 LLCs over the last number of years that we've put together for properties that have mortgages on them. Although everyone was jumping up and down and worrying about that, not a single one did we have an issue with the bank. We had some inquiries from the bank, that's for sure. And then let me give you the reasons why that occurs. So the bank calls and says, hey, you transferred the property into an LLC, that you weren't supposed to do that. And you say, well, let me ask you a question. Are you still the same beneficial owner before and after? Yeah. Did you own the property? Yeah. Do you own the LLC in the same proportion? Yeah. Is your security interest on the property still the security interest on the property? Yeah. I said, let me ask you a question, Mr. Banker. If there is a liability, is the equity in the property, which is your security, more protected now or less protected for you? Well, it's more protected for me. Then what are you doing? So if you have no increased liability, all right, and my client now doesn't have unlimited liability, to me, it's just bad faith. It looks like to me you're trying to play around with trying to get an increased fee or an increased interest rate. Now, at that point, they begin to back off and go away. And so the vast majority of times, I'd say 95 to 96% of the time, we have no problem dealing with lending institutions, and we get everything done. So it's just a question of how hard you work with the lending institutions, how hard you work with the insurers, how hard you work with the property assessor's office. But at the end of the day, the protection for you and the family is absolutely amazing. And the other
There's a
thing,
question about insurance for ADA lawsuits. I don't know if we got that
well,
answered that one.
The ADA is Jerry will deal with that. So that's a regulatory issue. So Jerry, why don't you go ahead and answer that question?
I love this question. Are you aware of any auto insurance that will cover you for a ticket for speeding or making a bad left turn?
I wish I had some.
Right. So the reason why insurance policies don't indemnify you for that is because really the law in California is that they want there to be a punitive circumstance associated with breaking the law, being caught, and being held accountable for it. And so if you are being sued over ADA issues, you are being prosecuted by either the state or through a PAGA action in which a private attorney is acting as the attorney general and is holding you accountable for regulatory rules and regulations that you are not meeting. And so, no, there isn't an insurance policy that I'm aware of that will react to an ADA complaint because it isn't bodily injury, it isn't property damage, it's regulatory, and regulatory is specifically not protected and indemnified. Now, there are places where regulatory can be purchased, like on an employment practices liability policy. You could purchase wage and hour violations, but what are you actually purchasing? You're purchasing a sublimit amount of protection for defense only and regulatory interaction with an attorney present. If you are found by the hearing officer or the court that you owed back wages and taxes, that's still coming out of your pocket because it's wages and taxes that you owe someone else. No one can indemnify you for what you owe. insurance is there to defend you and to indemnify you for injuries that you do it to a third party. But this is not an injury to a third party. This is a regulatory action. So for ADA compliance, your best defense is to become completely and adequately aware of the rules and regulations and be compliant.
And silo.
Right. And silo, that's another good point. Okay. And one more point is especially with ADA. There are a lot of exceptions to the ADA rules. There's a lot of attorneys out there bringing actions against people that don't actually even understand the laws and the rules that they're playing with. These are not the highest. This is the, what's the right way to say this? These are folks these are folks taking actions that most lawyers would not have the time or inclination to do. Okay, I'll say it that way. You need to understand that their entire business model is about trying to extract from you, okay, some sort of compromise and payment so that they can move on and sue 3 more people. So every time you fund one of these folks, by shoveling cash in their direction because you don't want to be disrupted by the circumstance, I find that the more you push back, the less effective they are, the less they engage you. So just be prepared to defend. Look at the rules and the laws and make sure that you actually are out of compliance, and then make sure that there aren't exceptions to the rules, because many of the rules have exceptions. So ADA now, unfortunately, is in its 35th year. I believe it was put into place during the first Bush's term. If you need to understand that all the buildings at this point that have had any renovations, that had any building permit, they've already gone through a process in which they could not get the permit if they didn't bring it up to code. So if your building hasn't been subject to that yet, then there's probably other things that are causations and exposures. And if you bring your building up to date, you're going to get better insurance, you're going to get better protection at a better price, you're going to have less likelihood of a loss, and you won't have to buy as big of umbrellas to protect your assets, okay? So those are all the incentives to doing things the right way. And, working with a good lawyer, working with a risk management focused insurance broker, okay? Those two things could be extraordinarily beneficial. And you know what? They aren't more expensive.
Yeah, we've got more questions. Suzanne, were you raising your
Let's do
hand?
questions now in the few minutes that we have left, please.
Okay, all right. Suzanne, I think you're
Suzanne, you're
muted.
muted.
I don't know if you can unmute yourself here. I think Tiffany, can you unmute Suzanne by
Yeah,
chance?
I did. I
Oh,
unmuted.
Okay, now
I'm
we can hear
sorry.
you.
Didn't even know. I live in Normandy Village, which is this California historic property. We cannot possibly, without ruining it, put ADA accessibility. They just can't live here. Sorry. I mean, we're up narrow stairways to I have a second floor over the garage apartment, mini stairs. There isn't any way in this world to build ADA accessible. So I don't know how there must be some limits on just because we're California historic property. Do you know?
I don't know that specifically, but my guess would be that a historic property does not have to meet that renovation. It's probably one of the exceptions Jerry was talking about. We can double check that for you, though,
Just
Suzanne.
curious. Yeah, I'd like to know, but there isn't much of anything I could do about it.
Right.
yeah.
It's a
Question.
curved, narrow stairway, probably 20 steps up.
Yeah, yeah.
Sure.
Sounds like a
Other
lovely
questions?
building. Yeah. If I have a living trust with only one person and I create an LLC with only the same person, can I move my real estate without changing the assessed value?
Yes. The answer is yes. Absolutely yes.
Okay. Moving the real estate from the trust to the LLC without assessed value. Yeah. What if I live in California, but the properties are in Texas? Does the LLC need to be in Texas or can it be in California?
Okay, well, yeah, that's a really good question, and it should be in Texas. It could be in California that's authorized to do business in Texas, or it could be in Texas with the manager authorized to do business in California. Texas has much better LLC law than California. The property is located in Texas. Liability is going to happen in Texas, so it'd be better to be a Texas liability LLC rather than California. Texas is one of the better states.
Okay. Somebody else asked if the link is good for a consult with Jerry. The answer is yes.
Yes.
If you click on that link, fill it out, it will get you to both Harry and Jerry. We'll get introduced to both of them for a free consult. I'm looking, any other questions we have here? Anybody?
Well, let me
I
do it. Let
saw
me
a
do it.
question
Oh,
that didn't get addressed. It was a question about, will a mortgage company have an issue if you want to move a property into an LLC? And I think that you addressed it kind of, Harry,
I
but
did.
can you just address that? Uh, uh, do you think you addressed it adequately?
Yeah, I think so. I think that the vast majority of times, we were able to accomplish that without any issues from the mortgage company. Um, there are some exceptions and there are some alternatives. We're just talking about LLCs today. We only had an hour. We could spend 3 hours talking about the use of irrevocable trust. One of the things I do want you to all understand that what is not a good way to hold real property is in a corporation. An S corporation or a corporation is no good. Not good from a tax perspective. And more important, that if I have a liability against Jack, all right, and you have a corporation that holds your real property, I get the stock. Or if I take the stock, the remedy is different. Now I own the corporation, I could liquidate the property. So it didn't give us that downside protection that we get from an LLC in a proper jurisdiction. And also understand that LLCs, that, it's not just forming the LLC, it's writing the operating agreement, it's transferring the property to make sure that there is no reassessment that's involved. And then just a little teaser over here. We do have a way in California, which is interesting. So it's way more complicated than we have time to talk about here, where we can leave assets or we can leave real property to the next generation without it being reassessed. It's a little bit to do. So if someone has a property that has an assessed value from 35 years ago, and we want to leave that to the next generation, there are some exceptional ways that we can get that to the next generation with the old 35-year assessed value. So just put it out there that it's something that we can talk about. It's just way beyond the time that we have today.
Yeah,
Any
hey,
other questions? If not, we want to
a couple
say, yeah,
more.
go ahead.
Harry, really quickly,
You're
if
not.
it's not reassessed, then you don't get the step up either, right?
You
Excuse
can
me?
leave
Yeah,
property.
yeah. The step up in basis has nothing to do with the property tax reassessment. Step up
Thank
in
you.
basis happens when you die, and then there's a step up in basis.
Where is the link?
In a corporation, there's no
Where-
step-up basis. I think that's what he's
Oh, the
saying.
link for the consult.
Yes.
Tiffany, are you putting it back in there?
It's in the chat. Can you access the chat, Andy? If you click the chat button, I'll also send it to all attendees in the room via email
Thank you.
after this, since some people are having trouble finding the chat.
Super. All right,
Yeah.
and with that, so I'm going to turn around and say, well, it's great to be back in Berkeley Home, Rental Property Association. There's a lot to talk about. So we are offering each and every one of you, Jerry and I, a consultation. Leave your checkbook home. We can answer all personal questions, spend some time, quality time with you, getting all these things answered. Take advantage of it. It's our give back to the association for having us with you. And I hope that at least I've impressed upon you. Look at this. There are great ways to own real property in California that are protected for you. And Jerry, there's great ways to insure them. The combination of the two, that Jerry likes to call it hand in glove, is critically important. And with that, I have to run. So thank you all very, very much. Tiffany, everybody,
Thank you,
Jerry,
Harry.
Paul,
Thank you,
thank you
everybody.
so
Thank you,
much. I
everybody.
hope we were helpful for
Thank
you. Thank
you.
you. Bye-bye.
Absolutely. Thanks,
Bye-bye.
members. We'll see you next time.
Uh,
Bye.
we-